I'm coming from Brussels, and I listened to this very, very interesting discussion. Some remarks. First, in France now, from the 1st of October, the possibility to modify the contract in case of new circumstances is recognized. It's more or less recognized everywhere. Secondly, concerning the case itself, I remember that there was a kind of monopoly. There was no choice for the tenant. It's an element which has to be taken into consideration when you decide on the case. Then all the people emphasized the fact that they could insert a clause in the contract concerning the change of currency, of the depreciation of the currency, what is totally correct. From my knowledge in comparative law, the fact that you insert a clause or not insert a clause does not impede the application of the law of change of circumstances. Only to give a very small example, in '67 there was a long-term supply contract in America between an aluminum company and 10 years contract. The clause was drafted by the chairman of the future chairman of the Reserve Board in America, Greenspan. This very well thought clause, but anyway, due to the fact that the losses of the seller were so high, the Supreme Court of America accepted the adaptation of the contract. It's really a question of fact, and here I heard that the price was more than 2 times higher. That's very impressive. And I think personally, I see that jus et arx boni et equi. That means that really what the judge has to find what is the good solution. And when I follow this maxim, I think it's a very important element. It's the fact that somebody is making a lot of profit and the other party is making big losses. That's always an element that a judge has to take into consideration. Then next point, concerning the renegotiation, and what was stressed this morning is true, is that you have to see the impact of all the parties. If the landlord has to pay his own loan, that's an element which has to be taken into consideration by the judge. Thus, ars equit boni, really to take all the elements into consideration is very important. For the renegotiation, I know that in other countries, for instance in France or in other countries, they put some rules for the renegotiation. Of course, it must be equilibrated, but for instance in a building contract, you are entitled to the compensation of your loss minus 20%, because that's the risk of the contractor. That's only a situation. And last point, what is true is that here there is a general measure, this depreciation. It has an impact everywhere. You have to think whether it is not good when you issue such a law to foresee also the impact on the contracts. I repeat, during the wars, this morning, and in a lot of cases when there is a specific rules, they foresee also what will be the effect on the contract of such a rule, because of course here there is a big impact. Many thanks.